Q. 31. Write a note on constitution and functioning of following. A. Industrial Tribunal. B. Income Tax Appellate Tribunal. C. Railway Rates Tribunal. Ans. A. Industrial Tribunal. The Industrial Tribunal is set up under the Industrial Disputes Act, 1947. It can be constituted by the central government if an industrial dispute relates or in any way concerns the central government, but where the Government of India has no such direct interest, the appropriate government may constitute the tribunal. An industrial dispute means any dispute or difference between I. Employers and employees, or 2. Employers and workmen, or 3. Workmen and workmen, which is connected with A. The employment or non-employment, B. The terms of employment, or C. The conditions of labor. Section 7- If the Industrial Disputes Act, 1947 provides as follows. 1. The appropriate government may, by notification in the Official Gazette, constitute one or more industrial tribunals for the adjudication of industrial disputes relating to any matter, whether specified in the second schedule or the third schedule. 2. A tribunal shall consist of one person only to be appointed by the appropriate government. 3. A person shall not be qualified for appointment as the presiding officer of a tribunal unless A. He is or has been a judge of High Court, or B. He has held the office of the chairman or any other member of the Labour Appellate Tribunal constituted under Industrial Disputes, Appellate Tribunal, Act, 1950 or of any tribunal for a period of not less than 2 years. 4. The appropriate government may, if it so thinks fit, appoint 2 persons as assessors to advise the tribunal in the proceedings before it. Section 10, 1d, provides, where the appropriate government is of the opinion that any industrial dispute exists or is apprehended, it may at any time by order in writing refer the dispute or any matter appearing to be connected with or relevant to the dispute to a tribunal for adjudication. Section 10, 4, further provides that where in an order referring an industrial dispute to a tribunal, the appropriate government has specified the points of dispute for adjudication, the tribunal shall confine its adjudication to these points and matters incidental thereto. The tribunal follows fair procedure and ensures the basic procedural safeguard to the parties. It holds the proceedings in public. A presiding officer of the tribunal may, for the purpose of enquiry into any existing or apprehended industrial dispute, after giving reasonable notice, enter the premises occupied by any establishment to which the dispute relates. Every tribunal shall have the same powers, which are vested in a civil court, under the Code of Civil Procedure, 1908, when trying a suit, in respect of following matters, namely, A. Enforcing the attendance of any person and examining him on oath. B. Compelling the production of documents and material objects. C. Issuing commissions for the examination of witnesses. D. In respect of such other matters as may be prescribed, and every inquiry or investigation by a tribunal shall be deemed to be judicial proceedings within the meaning of Section 193 and of the Indian Penal Code. Every tribunal shall be deemed to be a civil court for the purposes of Sections 480 and 482 of the Code of Criminal Procedure, 1898. In L. Chandra Kumar v. Union of India Air 1997 SC 1125 it was observed. The proceedings conducted by the Industrial Tribunal are judicial proceedings, and the decisions and awards are subject to the writ jurisdiction of the High Court under Article 226 of the Constitution. The tribunal is also subject to the supervisory jurisdiction of the High Court under Article 227 of the Constitution. Article 136 of the Constitution vests the Supreme Court with discretion to entertain appeals against the orders of tribunals by granting special leave. B. Income Tax Appellate Tribunal. The Income Tax Tribunal is constituted under the Income Tax Act, 1961. It consists of as many judicial and accountant members as the central government thinks fit. A judicial members must have held at least for 10 years a judicial post or must have been a member of the Central Legal Services, not below grade 3, for at least 3 years or must have been in practice as an advocate for at least 10 years. An accountant member must be a chartered accountant under the Chartered Accountants Act, 1949, and must have practiced as such for 10 years or must have served as Assistant Commissioner for at least 3 years. Appointments are made by the central government. The chairman of the tribunal shall be appointed from amongst the judicial members. The President of India regulates the conditions of service of the members in exercise of powers conferred by the proviso to Article 309 of the Constitution. Appeals can be filed before the tribunal by an aggrieved party against orders passed by the Appellate Assistant Commissioner, Inspecting Assistant Commissioner or Commissioner within a period of 60 days. The tribunal shall decide the matter only after giving both the parties to the appeal an opportunity of being heard. If the parties do not appear at the time of hearing, the appeal may be adjourned or heard ex parte. The assessee is entitled to appear before the tribunal personally or through an authorized agent including a lawyer. The tribunal is not governed by the rules of evidence applicable to the courts of law and is empowered to regulate its own procedure. It gives oral hearing to the parties and passes appropriate orders. The proceedings before the tribunal are deemed to be judicial proceedings. It has the power of summoning witnesses, enforcement of attendance, discovery and inspection, production of documents, and issue of commissions, as it has been given powers of a civil court under the Code of Civil Procedure, 1908. It can order prosecution of persons who produce false evidence or fabricate such evidence, and they may be punished under the Indian Penal Code, 1860. It may also take appropriate actions for its contempt. It may impound and retain books of account. The proceedings of the tribunal are not open to public. The decisions of the tribunal on questions of fact are final. No regular appeal is provided by the Act against the decision of the tribunal even on questions of law, but a reference can be made at the request of either party to the High Court on any question of law or directly to the Supreme Court if the tribunal is of the opinion that there is conflict of opinions amongst the High Courts. C. Railways Rates Tribunal. Indian Railway Rates Tribunal is established under the Indian Railways Act, 1989. It consists of a chairman who is or has been a judge of the Supreme Court or of a High Court, and 2 members. One shall be a person who, in the opinion of the central government, has special knowledge of commercial, industrial or economic conditions of the country, and the other shall be a person who, in the opinion of the central government, has special knowledge and experience of the commercial working of the railways. They shall be appointed by the central government, and the terms and conditions of their appointment may be such as the central government may prescribe. The members so appointed are to hold office for such period as may be specified in the order of appointment, not exceeding 5 years. No member can be reappointed. The tribunal is a quasi-judicial body, having all the attributes of a civil court under the Code of Civil Procedure, 1908. It has power to summon witnesses, take evidence, order discovery and inspection of documents, issue commissions, etc. The proceedings of the tribunal are deemed to be judicial proceedings within the meaning of Section 195 and Chapter XXVI of the Code of Criminal Procedure, 1973. The tribunal is not bound by strict rules of evidence and procedure and is empowered to frame its own rules for the purpose of practice and procedure, subject to approval of the central government. The tribunal has the power to hear complaints against the railway administration relating to discriminatory or unreasonable rates levied by it, classification of goods, or in giving undue preference to a particular person. The tribunal acts with the aid of assessors, who are selected from a panel prepared by the central government. This panel includes representatives of trade, industry, agriculture, and persons who have a working knowledge of the railways. They are selected after consultation with the interests likely to be affected by the decisions of the tribunal. A party before the tribunal is entitled to be heard in person or through an authorized agent including a lawyer. The decision of the tribunal is to be made by a majority of members. Its decision is final and can be executed by a civil court, as if it were a decree. The tribunal can revise its order on an application being made by the railway administration if the tribunal is satisfied that, since the order was made, there has been a material change in the circumstances. Q32. Do you agree with the view that principles of natural justice are to be followed by tribunals? Ans. As discussed above, administrative tribunals exercise judicial and quasi-judicial functions as distinguished from purely administrative functions. An essential feature of these tribunals is that they decide the disputes independently, judicially, objectively, and without any bias for or prejudice against any of the parties to the dispute. Different tribunals have different rules of procedure. The procedure which an industrial tribunal is required to follow is in the rules made under the Industrial Disputes Act, 1947. The Railway Rates Tribunal has been empowered to make rules for practice and procedure that it would follow. But one thing is common in the procedure followed by all the tribunals. Each of them is given the power of a civil court acting under the Code of Civil Procedure in respect of the following matters. I. Discovery and inspection. 2. Enforcement of attendance of any person. 3. Compulsory production of documents and other evidence. 4. Issuing of commission. Again, the proceedings of the tribunals are declared to be judicial proceedings for purposes of sections 193 and 228 and for purposes of section 196 of Indian Penal Code. It is also provided that the tribunal shall be deemed to be civil court for purposes of section 346 of the Code of Criminal Procedure, 1973. Section 193 of Indian Penal Code provides penalty for giving or fabricating false evidence in any stage of judicial proceeding. Section 228 provides punishment for intentional insults to public servant while sitting in any stage of judicial proceeding. Under sections 340 to 345 of C.R.P. Code, 1973 provisions have been made for the prosecution of the offences affecting the administration of justice. Thus, by extending the application of these provisions to the proceedings of a tribunal, the Law Commission in its 14th report, 1958, has observed that administrative tribunals perform quasi-judicial functions and they must act judicially and in accordance with the principles of natural justice. Administrative tribunals must act openly, fairly, and impartially. They must afford a reasonable opportunity to the parties to represent their case and to adduce the relevant evidence. Their decisions must be objective and not subjective. Q33. Discuss the scope of Administrative Tribunal Act 1985. Ans. In pursuance of the power conferred upon it by Clause 1 of Article 323 of Constitution, Parliament enacted the Administrative Tribunals Act, 1985. The statement of objects and reasons of the Act indicates that it was in the express terms of Article 323 of the Constitution and was being enacted because a large number of cases relating to service matters were pending before various courts. It was expected that the setting up of such administrative tribunals to deal exclusively with service matters would go a long way in not only reducing the burden of the various courts and thereby giving them more time to deal with other cases expeditiously, but would also provide to the persons covered by the administrative tribunals speedy relief in respect of their grievances. Administrative Tribunals Act 1985 contains 37 sections, which are housed in 5 chapters. Chapter 1, Preliminary, contains 3 sections. CL A of subsection 2 of Section 1 of the Act runs as follows. 2. It extends A. Insofar as it relates to the Central Administrative Tribunal, to the whole of India. B. Insofar as it relates to administrative tribunals for states, to the whole of India, except the state of Jammu and Kashmir. Section 3 is the definition clause. Chapter 2, Establishment of Tribunals and Benches thereof, contains sections 4 to 13. Section 4 empowers the central government to establish 1. A central administrative tribunal with benches at separate places. 2. An administrative tribunal for a state which makes a request in this behalf, and 3. A joint administrative tribunal for 2 or more states which enter into an agreement for the purpose. Section 5 states that each tribunal shall consist of a chairman and such number of vice-chairmen and judicial and administrative members as may be deemed necessary by the appropriate government. Subsection 2 of Section 5 requires every bench to ordinarily consist of 1 judicial member and 1 administrative member. Subsection 6 of Section 5, which enables the tribunal to function through single-member benches, is the focus of some controversy, as will subsequently emerge, and is fully extracted as under. Section 5(6). Notwithstanding anything contained in the foregoing provisions of this section, it shall be competent for the chairman or any other member authorized by the chairman in this behalf to function as a bench consisting of a single member and exercise the jurisdiction, powers and authority of the tribunal in respect of such classes of cases or such matters pertaining to such classes of cases as the chairman may by general or special order specify. Provided that if at any stage of the hearing of any such case or matter it appears to the chairman or such member that the case or matter is of such a nature that it ought to be heard by a bench consisting of 2 members, the case or matter may be transferred by the chairman or, as the case may be, referred to him for transfer to such bench as the chairman may deem fit. Section 6 deals with the qualifications of the personnel of the tribunal. Since the first few subsections of Section 6 are required to be considered subsequently, they may be reproduced hereunder. 6. Qualifications for appointment of chairman, vice-chairman or other members. 1. A person shall not be qualified for appointment as the chairman unless he A. is, or has been, a judge of a high court, or B. has, for at least 2 years, held the office of vice-chairman. C. 2. A person shall not be qualified for appointment as the vice-chairman unless he A. is, or has been, or is qualified to be a judge of a high court, or B. has, for at least 2 years, held the post of a secretary to the Government of India or any other post under the central or a state government carrying a scale of pay which is not less than that of a secretary to the Government of India, or B. has for at least 5 years held the post of an additional secretary to the Government of India or any other post under the central or a state government carrying a scale of pay which is not less than that of an additional secretary to the Government of India, or C. has, for a period of not less than 3 years, held office as a judicial member or an administrative member. 3. A person shall not be qualified for appointment as a judicial member unless he A. is, or has been, or is qualified to be, a judge of a high court, or B. has been a member of the Indian Legal Service and has held a post in grade 1 of that service for at least 3 years. 3-A. A person shall not be qualified for appointment as an administrative member unless he A. has, for at least 2 years, held the post of an additional secretary to the Government of India or any other post under the central or a state government carrying a scale of pay which is not less than that of an additional secretary to the Government of India, or B. has, for at least 3 years, held the post of a Joint Secretary to the Government of India, or any other post under the central or a state government carrying a scale of pay which is not less than that of a Joint Secretary to the Government of India, and shall, in either case, have adequate administrative experience. Subsections 4, 5, and 6 of Section 6 provide that all the members of the Central Administrative Tribunal, the State Administrative Tribunals, and the Joint Administrative Tribunals shall be appointed by the President. In the case of the State Administrative Tribunals and the Joint Administrative Tribunals, the President is required to consult the concerned governors. Subsection 7 stipulates that the Chief Justice of India is also to be consulted in the appointment of the Chairman, Vice Chairman, and members of all tribunals under the Act. Section 8 prescribes the terms of office of the personnel of the tribunal as being for a duration of 5 years from the date of entering into office. There is also provision for reappointment for another term of 5 years. The maximum age limit permissible for the chairman and the vice chairman is 65 years and for that of any other member is 62 years. Section 10 stipulates that the salaries, terms and conditions of all members of the tribunal are to be determined by the central government. Such terms are, however, not to be varied to the disadvantage of any member after his appointment. Chapter 3, Jurisdiction, Powers and Authority of Tribunals, consists of sections 14 to 18. Section 14, 15 and 16 deal with the jurisdiction, powers and authority of the Central Administrative Tribunal, the State Administrative Tribunals, and the Joint Administrative Tribunals, respectively. These provisions make it clear that except for the jurisdiction of this court, the tribunals under the Act will possess the jurisdiction and powers of every other court in the country in respect of all service-related matters. Section 14 provides Jurisdiction, Powers and Authority of the Central Administrative Tribunal. 1. Save as otherwise expressly provided in this Act, the Central Administrative Tribunal shall exercise, on and from the appointed day, all the jurisdiction, powers and authority exercisable immediately before this day by all courts, except the Supreme Court, in relation to a. b. all service matters concerning I and 2. 3. A civilian not being a member of an All India service or a person referred to in CL, C, appointed to any defence services or a post connected with defence, and pertaining to the service of such member, person or civilian, in connection with the affairs of the Union or of any state or of any local or other authority within the territory of India or under the control of the Government of India or of any corporation or society owned or controlled by the government. Section 17 provides that the tribunals under the Act will have the same powers in respect of contempt as are enjoyed by the High Courts. Chapter 4, Procedure, comprises sections 19 to 27. Section 21 specifies strict limitation periods and does not vest the tribunals under the Act with the power to condone delay. Chapter 5, Miscellaneous, the final chapter of the Act, comprising sections 28 to 37, vests the tribunals under the Act with ancillary powers to aid them in the effective adjudication of disputes. Section 28, the exclusion of jurisdiction clause reads as follows. 28. Exclusion of jurisdiction of courts on and from the date from which any jurisdiction, powers and authority becomes exercisable under this Act by a tribunal in relation to recruitment and matters concerning recruitment to any service or post or service matters concerning members of any service or persons appointed to any service or post, no court except a. the Supreme Court, or b. any industrial tribunal, labor court or other authority constituted under the Industrial Disputes Act, 1947 or any other corresponding law for the time being in force, shall have or be entitled to exercise any jurisdiction, powers or authority in relation to such recruitment or matters concerning such recruitment or such service matters. Pursuant to the provisions of the above said Act, the Central Administrative Tribunal, with 5 benches, was established on 1 November 1985. However, even before the tribunal had been established, several writ petitions had been filed in various High Court as well as Supreme Court challenging the constitutional validity of Article 323 of the Constitution, as also the provisions of the Act. The principal violation complained of being the exclusion of the jurisdiction of this court under Article 32 of the Constitution and of that of the High Courts under Article 226 of the Constitution. Through an interim order dated 31 October 1985, reported as SP Sampath Kumar v. Union of India, 1985, 4 SCC 458 Apex Court directed the carrying out of certain measures with a view to ensuring the functioning of the tribunal along constitutionally sound principles. When Sampath Kumar's case, AIR 1987 SC 386, was finally heard, these changes had already been incorporated in the body and text of the Act. The court took the view that most of the original grounds of challenge, which included a challenge to the constitutional validity of Article 323A, did not survive and restricted its focus to testing only the constitutional validity of the provisions of the Act. In its final decision, the court held that though judicial review is a basic feature of the Constitution, the vesting of the power of judicial review in an alternative institutional mechanism, after taking it away from the High Courts, would not do violence to the basic structure so long as it was ensured that the alternative mechanism was an effective and real substitute for the High Court. Using this theory of effective alternative institutional mechanism as its foundation, the court proceeded to analyze the provisions of the Act in order to ascertain whether they passed constitutional muster. The court came to the conclusion that the Act, as it stood at that time, did not measure up to the requirements of an effective substitute and, to that end, suggested several amendments to the provisions governing the form and content of the tribunal. The suggested amendments were given the force of law by an amending Act, Act 51 of 1987, after the conclusion of the case, and the Act has since remained unaltered. Q. 34. Discuss the jurisdiction and scope, powers of Central Administration Tribunal. Ans. The powers exercised by the Central Administration Tribunal shall be similar to those exercised by courts immediately before the commencement of this Act. However, the powers of Supreme Court are not fettered by this Act. The Central Administrative Tribunal shall exercise its powers in relation to I. Recruitment, and matters concerning recruitment, to any All India service or to any civil service or to any civil service of the Union or a civil post under the Union or to post connected with defence or in the defence services, being in either case, a post filled by a civilian, and 2. All service matters concerning A. A member of an All India service, or B. A person appointed to any civil service of the Union or any civil post under the Union, not being a member of an All India service of a person referred to in 3. C. A civilian appointed to any defence service or a post connected with defence, not being a member of All India service or a person referred to in 3. 3. All service matters pertaining to service in connection with the affairs of the Union concerning a person appointed to any civil service of the Union or any civil post under the Union or concerning a civilian who has been appointed to any defence service or a post connected with defence, and a person whose services have been placed by a state government or any local or other authority or any corporation or society or other body, at the disposal of the central government for such appointment. When the jurisdiction can be attracted, the jurisdiction of administrative tribunal can only be attracted when it is proved that other remedies have been exhausted. Section 20. When the tribunal satisfies that other remedies have been exhausted, then only it will entertain the application, otherwise not. In this regard, subsection 1 to section 20 says that a tribunal shall not, ordinarily, admit an application unless it is satisfied that the applicant had availed of all the remedies available to him under the relevant service rules as to redressal or grievance. Following are the conditions when a person shall be deemed to have availed of all the remedies available to him. I. If a final order has been made by the government, or 2. Such final order has been made by other authority or officer, or other person competent to pass such order under such rules, rejecting any appeal preferred or representation made by such person in connection with the grievance, or 3. Where no final order has been made by the government or other authority or officer or person competent to pass such order with regard to appeal preferred or representation made by such person, if a period of 6 months from the date on which such appeal was preferred or representation was made has expired. Q. 35. What do you mean by administrative discretion? State the grounds on which the conferment, non-use and abuse of discretion can be challenged in a court of law. Ans. Administrative discretion. Administrative discretion means choosing from amongst the various available alternatives, but with reference to the rules of reason and justice and not according to personal whims. Such exercise is not to be arbitrary, vague and fanciful, but legal and regular. The government cannot function without the exercise of some discretion by the officials. It is necessary not only for the individualization of the administrative power, but also because it is humanly impossible to modern government. But it is equally true that the absolute discretion is a ruthless master. It is more destructive of freedom than any of man's other inventions. Therefore, a reasonable exercise of discretion is the need of the hour. By the best definition of administrative discretion, we mean that a determination may be reached, in part at least, upon the basis of consideration not entirely susceptible of proof or disproof. It may be practically convenient to say that discretion includes the case in which the ascertainment of fact is legitimately left to administrative determination. Grounds to challenge conferment of power. I. The Act does not lay down any guideline for the exercise of the power by the delegated authority, as a result of which the authority is in a position to act according to his whims. In other words, the Act conferred unguided power on the authority and is therefore ultra vires, an Pursurum v. State of T.N. AIR 1990 SC 40. 2. If a statute does not disclose a definite policy or the objective, subject to which the administrative power is to be exercised, then the statute may be held to be discriminatory or restrictive of fundamental freedoms. Thus, this ground relates to the constitutionality of the law under which such powers are delegated with reference to the fundamental rights. Grounds to challenge abuse of discretion. I. The authority has acted mala fide I with dishonest intention or corrupt motive. For example, administrative action is used against an individual for satisfying a private or personal grudge of the authority. In Roji v. State of A.P., held that Chief Minister had acted mala fide in giving directions regarding the selection of particular transport routes for nationalization, as he sought to take vengeance against the private operators on those routes, as they were his political opponents. 2. The authority has taken irrelevant consideration or has failed to take into account relevant considerations. In State of Bombay v. K.P. Krishnan, the government refused to refer an industrial dispute for adjudication for the reason that the workmen resorted to a go-slow during the year. Held that the government acted for an improper purpose or it took into account irrelevant considerations. 3. The authority has not acted on any material but has acted in an arbitrary manner. In Stilekha Vidyarthi v. State of UP, removal en bloc of all district government pleaders in the state was held to be arbitrary and violative of Article 14 of the Constitution. Where the Indian Oil Corporation, a public sector corporation, abruptly stopped giving supplies of lubricants to a firm which had been carrying on the business of sale of lubricants for last 18 years, and no notice was given of such stoppage of supply, the action was held to be arbitrary. Mahabir Auto Stores v. Indian Oil Corporation. 4. The subjective satisfaction of the authority is based on non-relevant and extraneous considerations. For example, refusal to grant license should not be based on irrelevant considerations. State of UP v. Raza Ram Jaiswal AIR 1985 SC 1108. Grounds to challenge non-use of discretion. I. The authority exercises its discretion under dictation from a superior authority and does not consider the matter itself. In State of Punjab v. Hari Kishan, the application for grant of a cinema license made to the licensing authority was forwarded to the state government. The court quashed the said procedure. 2. The authority fetters its discretion by declaration of rules or policy to be followed by it uniformly in all cases, instead of applying it from case to case. Sri Rama Sugar Industries Limited v. State of AP. 3. The authority acts mechanically and without due care. In Nandalal v. Bar Council, Gujarat, the Bar Council immediately acted on a complaint by a person against a lawyer, in disfavor of the lawyer. The court held that some investigation has to be conducted by counsel before acting on a complaint and referring matter to the disciplinary committee. 4. The authority subdelegates its power, while the statute does not contain an express provision to this regard. Q. 36. Discuss the nature and scope of judicial review over administrative actions. Ans. Judicial review, meaning judicial review, is a great weapon in the hands of judges. It comprises the power of a court to hold unconstitutional and unenforceable any law or order based upon such law or any other action by a public authority which is inconsistent or in conflict with the basic law of the land. Broadly speaking, judicial review in India deals with three aspects. I. Judicial review of legislative action. 2. Judicial review of judicial decision, and 3. Judicial review of administrative action. We are concerned with the last aspect, namely, judicial review of administrative action. The underlying object of judicial review is to ensure that the authority does not abuse its power and the individual receives just and fair treatment, and not to ensure that the authority reaches a conclusion which is correct in the eye of law. Judicial review of administrative action is perhaps the most important development in the field of public law in the second half of this century. In India, the doctrine of judicial review is the basic feature of our constitution. Judicial review is the most potent weapon in the hands of the judiciary for the maintenance of the rule of law. Judicial review is the touchstone of the constitution. In recent times, judicial review of administrative action has become extensive and expansive. The traditional limitations have vanished and the sphere of judicial scrutiny is being expanded. Under the old theory, the courts used to exercise power only in cases of absence or excess or abuse of power. As the state activities have become pervasive and giant public corporations have come in existence, the stake of public exchequer justifies larger public audit and judicial control. The pattern of judicial review in this area reflects reconciliation of two conflicting values. The court is not an appellate forum where the correctness of the order of government could be canvassed, and, indeed, it has no jurisdiction to substitute its own view. However, since the legislature cannot have intended that the executive be the final judge of the extent of its own powers, the courts have come into picture and keep administration within the confines of the law. The courts are concerned with legality rather than with the merits of an administrative order. They would not go into the question whether there was sufficient or adequate or satisfactory material for the authority to form its opinion. The judicial control of administrative discretion in UK, USA and India converges on the same point despite divergent constitutional structurizations. In UK, the courts have always held that the concept of unfettered discretion is a constitutional blasphemy. In USA, besides the judicial review of administrative discretion, which is available in the Due Process Clause, the Administrative Procedure Code, 1946 specifically provides for judicial review. In India, there is no such specific provision, so the power of judicial review arises from the constitutional configuration of courts. Though courts in India have developed a few effective parameters for the proper exercise of discretion, the conspectus of judicial behavior still remains halting, variegated and residual, and lacks the activism of the American courts. Judicial review. Limitations. Judicial review has certain inherent limitations. It is suited more for adjudication of disputes than for performing administrative functions. It is for the executive to administer the law, and the function of the judiciary is to ensure that the government carries out its duty in accordance with the provisions of the Constitution. The duty of the court is to confine itself to the question of legality. It is to consider whether a decision-making authority exceeded its powers, committed an error of law, violated rules of natural justice, reached a decision which no reasonable man would have reached, or otherwise abused its powers. Though the court is not expected to act as a court of appeal, nevertheless it can examine whether the decision-making process was reasonable, rational, not arbitrary, or not violative of Article 14 of the Constitution. The parameters of judicial review must be clearly defined and never exceeded. If the authority has faltered in its wisdom, the court cannot act as super auditor. S.R. Bommai v. Union of India, 1994, 3 SCC 1, unless the order passed by an administrative authority is unlawful or unconstitutional, power of judicial review cannot be exercised. An order of administration may be right or wrong. It is the administrator's right to trial an error, and so long as it is bona fide and within the limits of the authority, no interference is called for. In short, power of judicial review is supervisory in nature. Unless this restriction is observed, the court, under the guise of preventing abuse of power by the administrative authority, will itself be guilty of usurping power. S.R. Bommai's case. In Indian Railway Construction Co. Limited v. Ajay Kumar AR 2003 SC 1843, it was observed that administrative action is stated to be referable to broad area of governmental activities in which the repositories of power may exercise every class of statutory function of executive, quasi-legislative and quasi-judicial nature. It is trite law that exercise of power, whether legislative or administrative, will be set aside if there is manifest error in the exercise of such power, or the exercise of the power is manifestly arbitrary. The court will be slow to interfere in such matters relating to administrative functions unless decision is tainted by any vulnerability like illegality, irrationality, and procedural impropriety. Whether action falls within any of the categories has to be established. Mere assertion in that regard would not be sufficient. To arrive at a decision on reasonableness, the court has to find out if the administrator has left out relevant factors or taken into account irrelevant factors. The decision of the administrator must have been within the four corners of the law, and not one which no sensible person could have reasonably arrived at, having regard to the above principles, and must have been a bona fide one. The decision could be one of many choices open to the authority, but it is for that authority to decide upon the choice and not for the court to substitute its view. To characterize a decision of the administrator as irrational, the court has to hold, on material, that if is a decision so outrageous as to be in total defiance of logic or moral standards. Q. 37. Discuss mala fides as a ground of challenge of administrative action. State the rules regarding burden of proof in petition on this ground. Ans. Mala fides, it means dishonest intention or corrupt motive. Mala fide exercise of power does not necessarily imply any moral turpitude as a matter of law. It only means that the statutory power is exercised for purposes foreign to those for which it is in law intended. In this sense, mala fides is equated to any ultra vires exercise of administrative power. However, the term is not used in such a broad sense, but in the narrow sense, dishonest intent. In Pratap Singh v. Punjab, AIR 1964 SC 72, the court used the phrase mala fides for initiating administrative action against an individual for satisfying a private or personal grudge of the authority. Though precise and scientific definition of the expression mala fide is not possible, it means ill will, dishonest intention or corrupt motive. A power may be exercised maliciously, out of personal animosity, ill will or vengeance, or fraudulently and with intent to achieve an object foreign to the statute. From the above definition, it can be said that malice is of two types. 1. Express malice or malice in fact, and 2. Implied or legal malice or malice in law. Mala fides violating proceedings may be factual or legal. Former is actuated by extraneous considerations, whereas the latter be without malicious intention or improper motive. In other words, a plea of mala fide involves two questions. I. Whether there is a personal bias or oblique motive, and 2. Whether the administrative action is contrary to the objects, requirements, and condition of a valid exercise of power. Burden of proof in mala fide exercise of power is required to be proved by the person who alleges it. Unlike the case of bias where it is enough to prove the likelihood of bias, in the case of mala fide the actual prejudice has to be proved. That is why it is difficult to prove mala fides. The following factors are important in the proof of mala fides. I. Direct evidence, e.g. documents, tape recording, etc. 2. Course of events. 3. Public utterances of the authority. 4. Deliberate ignoring of facts by the authority. Failure to file affidavits denying the allegation of mala fides. However, if the allegations are of wild nature, there is no need of controverting allegations. In Shivajirao Patil v. Mahesh Madhav AIR 1987 SC-94, the High Court observed that although there was no direct evidence, it could reasonably be inferred that tampering with the answer books in the university examination had been done at the command of the Chief Minister. The Supreme Court on Appeal held that though no clean chit could be given to the Chief Minister, the High Court's observation has no legal basis. This case shows that it is difficult to prove mala fides. In Indian Railway Construction Co. Limited v. Ajay Kumar AIR 2003 SC 1843, it was observed that while examining the question as to practicability or otherwise of holding the enquiry where the High Court had proceeded on the footing as if the order of dispensing with enquiry was mala fide, even when there was no specific allegation of mala fides, and without any specific person against whom mala fides were alleged being impleaded in the proceedings, and except making a bold statement regarding alleged victimization and mala fides, no specific details were given, the approach of the High Court could not be said to be in the correct perspective and proper. Doubtless, he who seeks to invalidate or nullify any act or order must establish the charge of bad faith, an abuse or a misuse by the authority of its powers. While the indirect motive or purpose, or bad faith or personal ill will is not to be held established except on clear proof thereof, it is obviously difficult to establish the state of a man's mind, for that is what the employee has to establish, though this may sometimes be done. The difficulty is not lessened when one has to establish that a person apparently acting in the legitimate exercise of power has, in fact, been acting mala fide in the sense of pursuing an illegitimate aim. It is not the law that mala fide in the sense of improper motive should be established only by direct evidence. But it must be discernible from the order impugned or must be shown from the established surrounding factors which preceded the order. If bad faith would vitiate the order, the same can be deduced as a reasonable and inescapable inference from proved facts. It cannot be overlooked that burden of establishing mala fides is very heavy on the person who alleges it. The allegations of mala fides are often more easily made than proved, and the very seriousness of such allegations demands proof of a high order of credibility. Courts would be slow to draw dubious inferences from incomplete facts placed before it by a party, particularly when the imputations are grave and they are made against the holder of an office which has a high responsibility in the administration. Q. 38. The powers of Supreme Court under Article 32(2) are very wide. Discuss the statement with illustration from decided cases. Ans. The founding fathers of the Constitution of India were aware of the part played by prerogative writs in England. In these circumstances, they have made specific provisions in the Constitution itself empowering the Supreme Court and High Courts to issue writs in the nature of Habeas Corpus, Mandamus, prohibition, quo warranto and certiorari for enforcement of fundamental rights, Articles 32 and 226. Article 32 confers powers on the Supreme Court to enforce fundamental rights. Clause 1 of the article guarantees the rights to more Supreme Court for enforcement of rights enumerated under Article 32 and Clause 2 provides for the powers to the Supreme Court to issue directions, orders or writs including the writs of the nature of Habeas Corpus, Mandamus, Certiorari, prohibition and quo warranto. Thus, anyone who comes to this court with complaint that his fundamental rights have been infringed by the acts of the government or any other body of persons appointed by the government, the court has power to issue directions, orders or writs, as it might consider appropriate. It is said that the powers guaranteed under Article 32(2) are of far-reaching importance. They provide adequate remedies against the misuse and abuse of the powers by the administrative authorities. The Supreme Court enjoys a broad discretion in the matter of the framing of the writs to suit the exigencies of the particular cases, and the application of the petitioner cannot be thrown out by the court simply on the ground that the proper writ or direction has not been prayed for, per Justice Mukherjee in Chiranjit Lalvi, Union of India, 1950 SCR 869. In Janardhana Reddy v. State of Hyderabad AIR 1951 SC-17 it was observed that the power given to the Supreme Court under this provision is a large one, but it has to be exercised in accordance with well-established principles. The writs under the article must obviously be correlated to one or more of the fundamental rights conferred by Part 3 of the Constitution, and can be made only for the enforcement of such rights. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by Part 3 of the Constitution is itself a fundamental right. That being so, a right to obtain a writ when the petitioner establishes a case for it must equally be a fundamental right. It is, therefore, not merely a right of an individual to move the Supreme Court, but also the duty and responsibility of the Supreme Court to protect the fundamental rights. Daryao v. State of U.P. AIR 1961 SC 1457, the article aims at the enforcement of fundamental rights, no matter the necessity for such enforcement arises out of an executive action or any action of the legislature. If the legislature enacts any law, the enforcement whereof might abridge or take away the rights granted under Chapter 3. In that case the enactment might also be turned down by the Supreme Court. In Kochuni v. State of Madras, AIR 1959 SC 725, the Supreme Court pointed out that there might be a case where an enactment of the legislature might immediately on coming into force take away or abridge the fundamental rights of a person by its very terms and without any further act being done. In such a case, the infringement of a fundamental right is complete to frustrate the passing of the enactment, and, therefore, there can be no reason why the person so prejudicially affected should not be entitled immediately to avail himself of the constitutional right has been infringed by the mere operation of an enactment, is not entitled to invoke the jurisdiction of this court under Article 32, for the enforcement of his right, will be to deny him the benefits of a statutory constitutional remedy which is itself his fundamental right. The court further pointed out that if a statute took away or abridged, by its very terms, and without anything more being done to the petitioner's fundamental right, a declaration as to the individuality of the impugned act together with the consequential relief by way of injunction restraining the respondent from asserting any right under the enactment so declared void, would be the appropriate remedy and the petitioner would be entitled to get it. Since Article 32 is itself a fundamental right, it cannot be whittled down by a legislation. It can be invoked even where an administrative action has been declared as final by the statute. In Prem Chand v. Commissioner, AIR 1963 SC 996, the Supreme Court struck down one of its own rules, requiring furnishing of a security to move a writ under Article 32 as unconstitutional on the ground that it retarded the assertion or vindication of the fundamental right under Article 32. In Fertilizer Corporation Kamgar Union v. Fertilizer Corporation, AIR 1981 SC 344, the jurisdiction conferred on Supreme Court has been characterized as an important and integral part of the basic structure of the Constitution, as it is meaningless to confer fundamental rights without providing an effective remedy for their enforcement, if and when they are violated. A right without a remedy is a legal conundrum of a most grotesque kind. Thus, the provisions under Article 32 have conferred very wide power on the Supreme Court. In D.C., State of Bihar, AIR 1987 SC 579, it was held that a writ petition is maintainable under Article 32 to ensure proper implementation of the constitutional provisions. Q. 39. What is the scope of Article 226 of India Constitution regarding the power of High Court to control the Administrative Act? Ans. Scope of Article of 226 of Constitution. Article 226 empowers every High Court to issue directions, order or writs in the nature of Habeas Corpus, Mandamus, Prohibition, Quo Warranto and Certiorari or any of them. Such directions, orders or writs may be issued. I. For enforcement of fundamental rights, or 2. For any other purpose. So far as the enforcement of fundamental rights is concerned, the jurisdiction of the High Court is substantially the same. If there is violation of a fundamental right, and it is the duty of the Supreme Court to enforce it, it is absurd to contend that there is no such duty on high courts to grant relief in case of violation of fundamental rights. In Devilal v. Sto. AIR 1965 SC 1150, 1965, 1 SCR 686. It was observed there can be no doubt that the fundamental rights guaranteed to the citizens are a significant feature of our Constitution, and the High Courts under Article 226 are bound to protect these fundamental rights. In Mohd Hanif v. State of Assam, 1969, to SC 782 it was observed that the jurisdiction of High Courts under Article 226 of the Constitution is equitable and should be exercised to ensure that the law of the land is obeyed and public authorities are kept within the limits of their jurisdiction. In a proceeding under Article 226, the High Court does not determine private rights of parties. It is a remedy against violation of rights by state or statutory authorities. It is a remedy in public law. In Roshan Dean v. Preeti Lal AIR 2002 SC 33, it was observed that the power conferred on the High Court under Arts. 226 and 227 of the Constitution is to advance justice and not to thwart it. The very purpose of such constitutional powers being conferred on the High Courts is that no man should be subjected to injustice by violating the law. The lookout of the High Court is, therefore, not merely to pick out any error of law through an academic angle but to see whether injustice has resulted on account of any erroneous interpretation of law. If justice became the byproduct of an erroneous view of law, the High Court is not expected to erase such justice in the name of correcting the error of law. In T.K. Rangarajan v. Government of T.N. AIR 2003 SC 3032, it was observed that it is established principle that where there is an alternative, effective, efficacious remedy available under the law, the High Court would not exercise its extraordinary jurisdiction under Article 226, and that has been reiterated by holding that the litigants must first approach the tribunals, which act like courts of first instance in respect of the areas of law for which they have been constituted, and therefore, it will not be open to the litigants to directly approach the High Court even where the question of views of the statutory legislation is challenged. But High Court is empowered to exercise its extraordinary jurisdiction to meet unprecedented extraordinary situation having no parallel. When the state government has dismissed to lack employees for going on strike, the situation is very, very exceptional. There was no justifiable reason for the High Court not to entertain the petitions on the ground of alternative remedy provided under the statute. In Chairman and Managing Director, United Commercial Bank v. P.C. Kakkar AIR 2003 SC 1571, it was observed that the court should not interfere with the administrator's decision unless it was illogical or suffers from procedural impropriety or was shocking to the conscience of the court, in the sense that it was in defiance of logic or moral standards. The court would not go into the correctness of the choice made by the administrator open to him, and the court should not substitute its decision to that of the administrator. The scope of judicial review is limited to the deficiency in decision-making process and not the decision. To put it differently, unless the punishment imposed by the disciplinary authority or the appellate authority shocks the conscience of the court tribunal, there is no scope for interference. Further, to certain litigation it may, in exceptional and rare cases, impose appropriate punishment by recording cogent reasons in support thereof. In the normal course, if the punishment imposed is shockingly disproportionate, it would be appropriate to direct the disciplinary authority or the appellate authority to reconsider the penalty imposed. The power of the High Court under the article is not confined to issuing of writs, it is broader, for under it, a High Court may also issue a suitable direction or order. Further, the words in the article in the nature of writs presumably imply that the High Court is not bound to follow all procedural technicalities of the English law relating to writs, or changes of judicial opinions from case to case. What appears to be necessary is that the High Courts keep the broad and fundamental principles of these writs as followed in the English law. Basappa v. Nagappa, AIR 1954 SC 440. In 1976, Article 226 was subject to an important change, and the scope of Article 226 has been restricted to fundamental rights only if there was another remedy available for the redress of the injury caused. But, the 44th Amendment Act, 1978 has restored the original position of the Article 226 in this context. There are following threefold restrictions on their exercise of the power to issue writs. 1. In the first place, the power is to be exercised throughout the territories in relation to which it exercises jurisdiction, i.e. writs issued by the court cannot run beyond the territories subject to its jurisdiction. 2. Secondly, the person or authorities to which the High Court issues such writs must be within those territories. It clearly implies that they must be amenable to its jurisdiction either by residence or location within those territories. 3. The powers so conferred on the High Courts should not be in derogation of the powers conferred on the Supreme Court by Clause 2 of Article 32. Thus, the powers of the High Court are very wide. It has been empowered to issue writs or directions against all governmental authorities. Its jurisdiction is extraordinary because these powers confer discretion of very extensive nature. Q40. Discuss the principles which would regulate the exercise of jurisdiction under Article 226. Ans. The powers granted the High Courts under the article are discretionary. 1. The discretion of the High Court has been found to have been used very widely. But the very vastness of the powers imposes on it the responsibility to use them with circumspection. Accordingly, the High Courts will be required to exercise the jurisdiction in accordance with judicial considerations and well-established principles. We have seen some constitutional limitations upon the exercise of the powers under this article. Such limitations are self-imposed or they may be called limitations inherent in the exercise of the discretion and jurisdiction. The following are some of the principles which govern such limitations. 1. An adequate alternative remedy. It is well established that the remedy provided for in Article 226 of the Constitution is a discretionary remedy, and the High Court has always the discretion to refuse to grant such a relief in certain circumstances even though a legal right might have been infringed. Availability of an alternative remedy is one of such considerations which the High Court may take into account to refuse to exercise its discretion. Than Singh's case AIR 1964 SC 1419, the underlying object is apparent and obvious. High courts are the apex judicial institutions in the states, and it is but natural that if an alternative, adequate, and equally efficacious remedy is available to the party, they may refuse to exercise this extraordinary jurisdiction and direct the aggrieved party to first avail of the said alternative remedy. It should, however, be remembered that the existence of an alternative remedy is not an absolute bar to the granting of writ under Article 226 of the Constitution. It is a rule of policy and practice and not a rule of law. It is a question of discretion and not of jurisdiction. Therefore, in exceptional case a writ can be issued notwithstanding the fact that an alternative remedy is available to the party and has not been availed of. Union of India v. T.R. Verma, AIR 1957 SC 882. Thus, if there is violation of a fundamental right, an aggrieved party has the right to move the Supreme Court under Article 32 or a High Court under Article 226. Similarly, if the remedy provided by the statute cannot be said to be alternative, adequate or equally efficacious, or the act by which such a remedy is provided is itself ultra vires or unconstitutional, or the impugned order is without jurisdiction or violative of the principles of natural justice, the court can grant relief to the petitioner. 2. Delay. The conduct of the petitioner will be taken into account when the court is considering his petition. Inordinate delay in invoking the jurisdiction of High Court may be a good ground for declining to grant a writ under Article 226. The petitioner should expeditiously come with the petition before the High Court. In Durga Prasad's case AIR 1964 SC 1006, it was observed that it is well settled that under Article 226, the power of a High Court to issue an appropriate writ is discretionary. One of the grounds for refusing relief under Article 226 is that the petitioner has been guilty of delay and laches. It is imperative, if the petitioner wants to invoke the extraordinary remedy available under Article 226 of the Constitution, that he should come to the court at the earliest reasonably possible opportunity. Inordinate delay in making the motion for a writ will be a good ground for refusing to exercise the discretion. It is essential that persons who are aggrieved by any order of the government or any executive action should approach the High Court with utmost expedition. 3. Suppression of fact. The petitioner must come with clean hands. He should not conceal or suppress any fact which is material in the consideration for the grant of the writ. In Narayan Das v. State, AIR 1953 Punjab, 1233 it was observed that if the applicant, for a writ under Article 226, is guilty of the suppression of material facts in his application and an attempt to mislead the court thereby has been made, his petition will be rejected and the court should refuse to consider it on merits. In Vijay Kumar v. State, AIR 1983 SC 622, it was held it is well settled that a party seeking relief under Article 32 or under Article 226 of the Constitution must be truthful, frank and open. He should disclose all relevant facts without any reservation. He cannot pick and choose the facts he likes to disclose and keep back or conceal other facts. The very basis of the writ jurisdiction rests on disclosure of correct facts. If material facts are suppressed, twisted or distorted, the very functioning of writ courts would become impossible. 4. Futility of the writ. If the writ applied for is not likely to serve any useful purpose, the court may in its discretion reject the application on this ground. Ravindra Nath v. Tax Officer AIR 1967 Mad. 299, Abdul Ghafoor v. State AIR 1968 MP 29. In Suresh v. Vasant AIR 1970 SC 1680, the Supreme Court stated the High Court, while granting relief under Article 226, should keep in view that no injustice will cause to opposite parties and that the issue of writ will not be futile. Thus the court refused to issue a writ against a student who was admitted to certain course and was about to complete it successfully when the petitioner himself is not eligible for admission to that course. 5. Disputed question of fact. The High Court is not required to dispose of disputed question of fact. Proceedings under Article 226 are of summary nature. In Raza Ram v. State, AIR 1958 All. 141 it was held that where the rights claimed by the applicant cannot be conveniently determined in such summary proceedings, the High Court, in exercise of its discretion, shall refuse to interfere by writ under Article 226. Q. 41. Discuss the scope and nature of writ of habeas corpus. Ans. Habeas corpus. The writ of habeas corpus is one of the most ancient writs known to the common law of England. Habeas corpus is a prerogative writ, which was granted to a subject of His Majesty, who was detained illegally in jail. So habeas corpus is an order of release. The words habeas corpus and subjecundum literally mean to have the body. It was defined in Halsbury's Laws of England in the following manner. Writ of habeas corpus is a prerogative process for securing the liberty of the subject by affording an effective means of immediate release from unlawful, unjustifiable detention and is available against the executive. In Dhananjay Sharma v. State of Haryana, AIR 1995 SC 1795 it was observed that whenever a question is raised regarding the illegal detention of a citizen in a writ of habeas corpus and the court issues the rule nisi, a duty is cast on the state, through its functionaries and particularly those who are arrayed as respondents to the writ petition, to satisfy the court that the detention of the citizen was legal and in conformity not only with the mandatory requirements of the law but also with the requirements implicit in Article 22(5) of the Constitution of India. It is obligatory on the part of the state to place before the court all relevant facts relating to the impugned detention truly, clearly and with utmost fairness through an affidavit. An affidavit in reply is required to be filed by the respondents not as a mere formality but to truly assist the court in drawing permissible inference from the rival contentions. The right of personal liberty of a citizen is all too precious and no one can be permitted to interfere with it except in accordance with the procedure established by law. The state owes an obligation to the courts to place all relevant facts before the court in all cases where a citizen with his fundamental rights alleges interference. The writ of habeas corpus provides a prompt and effective remedy against illegal restraints. Thus, the object of the writ of habeas corpus is to release a person from illegal detention and not to punish the detaining authority. The question for a habeas corpus court is whether the subject is lawfully detained. If he is, the writ cannot issue. If he is not, it must issue. History in England, habeas corpus is of common law origin. In India, the jurisdiction to issue prerogative writs came with the establishment of Supreme Courts at Calcutta, Bombay and Madras under the Regulating Act, 1773. On abolition of Supreme Courts and establishment of High Courts, the said power had been conferred on High Courts. Under the Constitution of India, the Supreme Court, Article 32, and all High Courts, Article 226, have power to issue a writ of habeas corpus. Who may apply an application for writ of habeas corpus may be made by the person illegally detained. But if the prisoner himself is unable to make such application, it can be made by any other person having interest in the prisoner. Against whom habeas corpus would lie, writ of habeas corpus may be issued against any person or authority who has illegally detained or arrested the prisoner. Procedure: every application for the writ of habeas corpus must be accompanied by an affidavit stating the facts and circumstances leading to the making of such an application. If the court is satisfied that there is a prima facie case for granting the prayer, it will issue a rule nisi calling upon the detaining authority on a specified day to show cause as to why the rule nisi should not be made absolute. On the specified day, the court will consider the merits of the case and will pass an appropriate order. If the court is of the opinion that the detention was not justified, it will issue the writ and direct the detaining authority to release the prisoner forthwith. On the other hand, if according to the court, the detention was justified, the rule nisi will be discharged. Where there is no return to the rule nisi, the prisoner is entitled to be released forthwith. When may be refused, since the object of the writ of habeas corpus is remedial and not punitive, the legality or otherwise of the detention must be decided by the court with reference to the date of return of the rule nisi and not with reference to the date of making such application. Thus, the writ would not be issued if at the time of the rule nisi, the prisoner was not illegally detained, even though at the time of detention the order was illegal. The following principles regarding a writ of habeas corpus emerge. 1. A writ of habeas corpus is a remedial writ, which can be issued in all cases of wrongful deprivation of individual freedom and personal liberty. 2. It, however, cannot be employed to impeach or otherwise challenge the correctness or propriety of a decision rendered by a court of competent jurisdiction. 3. An order of release by habeas corpus does not per se amount to discharge or acquittal of the prisoner or detainee. 4. Since a writ of habeas corpus is not punitive in nature, it cannot be utilized as an instrument of punishment of one who has wrongfully arrested or detained another. 5. A prisoner or detainee himself or his relative or his friend or any other person interested in the prisoner or detainee can move the court for a writ of habeas corpus. 6. Mere delay in applying for a writ of habeas corpus will not bar the prisoner or detainee from challenging arrest or detention. 7. When the detainee contends that he is wrongfully detained, the burden is on the authority to justify the detention. 8. The approach of the court in habeas corpus proceedings has to be one of eternal vigilance. The court must strike a balance between the need to protect the society on the one hand and the necessity to safeguard the liberty of a citizen on the other hand. 9. In habeas corpus proceedings, it is the duty of the state to place before the court all the material facts and relevant record truly, faithfully, and with utmost fairness. Q. 42. Define the writ of certiorari. Discuss its scope and nature. Ans. Certiorari is a Latin word meaning to inform. It was essentially a royal demand for information. The king wishing to be certified of some certiorari may be defined as a judicial order operating in personam and made in the original legal proceedings, directed to any constitutional, statutory or non-statutory body or person, requiring the records of any action to be certified by the court and dealt with according to law. It is a remedy operating in personam, therefore writ can be issued even where the authority has become functus officio to the keeper of the records. 2. Writ can be issued against constitutional bodies, legislature, executive and judiciary or their officers, statutory bodies like corporations, non-statutory bodies like companies and cooperative societies, and private bodies and persons. 3. Certiorari can be issued to quash judicial, quasi-judicial as well as administrative actions. The writ is corrective in nature, thus its scope of operation is quite large. 4. The purpose of certiorari is not only negative, to quash an action, but it contains affirmative or positive action also. In Gujarat Steel Tubes v. Mazdoor Sabha, AIR 1980 SC 1896, the Supreme Court held that while quashing the dismissal order, the court can also order reinstatement and the payment of back wages. A writ of certiorari can be issued if the following conditions are fulfilled. The judicial or quasi-judicial body must have legal authority. 2. Such authority must be an authority to determine questions affecting rights of subjects. 3. It must have duty to act judicially, and 4. It must have acted in excess of its authority. A writ of certiorari may be issued on the following grounds. Error of jurisdiction when an inferior court or tribunal acts without jurisdiction, in excess of its jurisdiction or fails to exercise jurisdiction vested in it by law, a writ of certiorari may be issued against it. 2. Jurisdictional fact. Lack of jurisdiction may also arise from absence of some preliminary facts, which must exist before a tribunal exercise its jurisdiction. They are known as jurisdictional or collateral facts. The existence of these facts is a sine qua non or a condition precedent to the assumption of jurisdiction by an inferior court or tribunal. To put it simply, the factor of facts upon which an administrative agency's power to act depends can be called a jurisdictional fact. If an inferior court or a tribunal wrongly assumes the existence of such a fact, a writ of certiorari can be issued. In Surya Dev Rai v. Ram Chandar Rai AIR 2003 SC 3044, it was observed that certiorari jurisdiction, though available, is not to be exercised as a matter of course. The High Court would be justified in refusing the writ of certiorari if no failure of justice has been occasioned. In exercising the certiorari jurisdiction, the procedure ordinarily followed by the High Court is to command the inferior court or tribunal to certify its record or proceedings to the High Court for its inspection so as to enable the High Court to determine whether on the face of the record the inferior court has committed any of the preceding errors occasioning failure of justice. Certiorari, under Article 226 of the Constitution, is issued for correcting gross errors of jurisdiction, i.e., when a subordinate court is found to have acted without jurisdiction by assuming jurisdiction where there exists none, or 2. In excess of its jurisdiction by overstepping or crossing the limits of jurisdiction, or 3. Acting in flagrant disregard of law or the rules of procedure, or acting in violation of principles of natural justice where there is no procedure specified, and thereby occasioning failure of justice. In Shaukin Singh v. Desha Singh AIR 1970 SC 672, the relevant statute empowered the Chief Settlement Commissioner to cancel an allotment of land if he was satisfied that the order of allotment was obtained by means of fraud, false representation, or concealment of any material fact. The Supreme Court held that the satisfaction of the statutory authority was a jurisdictional fact and the power can be exercised only on the existence there. 3. Error apparent on face of record. If there is an error of law, which is apparent on the face of the record, a decision of an inferior court or a tribunal may be quashed by a writ of certiorari. 4. Violation of natural justice. A writ of certiorari can be issued when there is violation of the principles of natural justice. We, who may apply normally the party whose rights are affected may apply for a writ of certiorari. But if the question affects the public at large, any person may apply. The distinction, however, is that where the application is made by the aggrieved party, the court should grant relief ex debito justitiae, but if it is made by a party not directly affected in the litigation, grant of writ is entirely in the discretion of the court. 6. Against whom certiorari would lie. A writ of certiorari is a judicial writ. It lies against subordinate courts, inferior tribunals, quasi-judicial bodies, and adjudicating authorities. 7. Alternative remedy. A writ of certiorari is a discretionary remedy, and the fact that the aggrieved party has another adequate remedy may be taken into consideration, and it may not be issued on that ground. But as discussed above, it is a rule of policy, convenience, and discretion, and not of jurisdiction, and in spite of alternative remedy being available, it may be issued where the order is on the face of it erroneous or the inferior court or tribunal has acted without jurisdiction or in excess of its jurisdiction or contrary to the principles of natural justice or there is infringement of a fundamental right of the petitioner. Q. 43. Define the writ of mandamus. Discuss its nature and scope. Ans. Mandamus means a command. It is an order issued by a court to a public authority asking it to perform a public duty imposed upon it by the Constitution or by any other law. Mandamus is a judicial remedy which is in the form of an order from a superior court, the Supreme Court, or a high court, to any government, court, corporation, or public authority to do or to forbear from doing some specific act which that body is obliged under law to do or refrain from doing, as the case may be, and which is in the nature of a public duty and in certain cases of a statutory duty. It is considered as a residuary remedy of the public law. It is a general remedy whenever justice has been denied to any person. It may be issued not only to compel the authority to do something but also to restrain it from doing something. Therefore, it is both negative and positive and hence can do the work of all other writs. It can be issued on all those counts on which certiorari and prohibition can be issued. Conditions for the grant of mandamus. 1. There must be a public duty. Mandamus would lie only to enforce a duty, which is public in nature. It will not issue against a private individual to enforce a private right such as a contract. Even though mandamus does not lie to enforce a contract inter partes, it will lie where the petitioner's contractual right with a third party is interfered with by the state. In Gujarat State Financial Corporation v. Lotus Hotel, AR 1983 SC 848, the Supreme Court issued writ of mandamus for the specific performance of a contract to advance money. In this case, the Gujarat Financial Corporation, a government instrumentality, had sanctioned a loan of 30 lakhs rupees to Lotus Hotel for the construction, but later on refused to pay the amount. Mandamus would not lie where the duty is ministerial in nature, i.e. where the authority has to act on the instructions of his superior. In the same manner, mandamus cannot be issued to enforce administrative directions or instructions which do not have the force of law, hence it is discretionary with the authority to accept it or reject it. 2. There must be a specific demand and refusal. There must be a specific demand for the fulfillment of duty and there must be specific refusal by the authority. However, express demand and refusal is not necessary. Demand and refusal can be inferred from the circumstances also. In Yogendra Kumar v. Delhi Ann. 1982, 3 SCC 506, the writ of Mandamus was issued to secure the release of a prisoner detained for not valid reasons. 3. There must be a clear right to enforce the duty. The applicant must have a legal right to the performance of a legal duty. The right sought to be enforced must be subsisting on date of petition. The right to enforce the duty must belong to the petitioner. However, this does not mean that a person can never enforce a public right which does not specifically belong to any individual. Mandamus can be issued on the petition of a taxpayer to restrain a municipality from misallocation or misappropriation of public funds. Against whom Mandamus would not lie. Writ of Mandamus will not lie against the President or the Governor of a state for the exercise and performance of powers and duties of his office or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. Article 361. It will not lie against the state legislature to prevent them from considering enacting a law alleged to be violative of constitutional provisions. Narinder Chand v. Lieutenant Governor, HP, 1971, to SCC 585, AIR 1969, SC 1306. Alternative remedy. A writ of Mandamus will not be refused on the ground of alternative remedy being available if the petitioner approaches the court with an allegation that his fundamental right has been infringed. It is the duty of the High Court to safeguard the fundamental rights of the petitioner, and the writ of Mandamus will be issued. But if the complaint is not about the infringement of any fundamental right, the availability of an alternative remedy may be a relevant consideration. Q. 44. Discuss the nature and scope of writ of quo warranto. Ans. Quo warranto. By issuing the writ of quo warranto, the court seeks from the person to whom it is issued information as to the warrant or authority by which the said person supports his right to an office, franchise or liberty. It lies against a person who claims or usurps an office, franchise or liberty with respect to which information is sought, so that such person's right to the same may be determined in the light of the authority or warranto cited by such person in support thereof. The writ of quo warranto cannot be issued unless the defendant is in actual possession of the office and exercises the office. R.V. Green, to QB 460. The holding of a liberty as a matter of fact is a condition precedent to the determination of a right to the same and the calling up of information with regard to it. A motion for a writ of quo warranto can be made at the instance of a private person although he is not personally aggrieved or interested in the matter. The motion does not require the intervention of the government or any public authority. This type of writ is a discretionary remedy and is not issued as a matter. In G. D. Karkare v. T. L. Shevde, AIR 1950 to NAD. 330, the appointment of the Advocate General of Madhya Pradesh was questioned by quo warranto. An objection was taken that mere a private individual seeking neither enforcement of his fundamental right nor any other legal right cannot ask for quo warranto. The High Court held that there was no reason to refuse a citizen under a democratic republican constitution to move for a writ of quo warranto for testing the validity of high appointment under the constitution. On merit, however, it was held that there was no defect in the appointment questioned in the writ. The writ of quo warranto can go only to public offices and not to private bodies like the managing committee of a school, as has been held in Amrendra v. Narendra, AIR 1953 calories. 114. Q. 45. What constitutional remedies are available to a person aggrieved of action of administrative authority? Ans. Under the Constitution of India, the following remedies are available to a person aggrieved by an action of administrative authority. A. Extraordinary remedies. As already discussed, an aggrieved party has a right to approach the Supreme Court under Article 32 or a High Court under Article 226 of the Constitution of India for an appropriate writ, direction or order. They are extraordinary or prerogative remedies. B. Appeals to Supreme Court. Articles 132 to 135 of the Constitution deal with appeal powers of the Supreme Court in constitutional matters and in civil and criminal cases. Article 139 enables the Supreme Court to withdraw or transfer cases from one court to another court. C. Special leave petitions. I. Constitutional provisions. Article 136 of the Constitution of India confers extraordinary powers on the Supreme Court to grant special leave to appeal from any judgment, decree, determination, sentence or order passed by any court or tribunal. 136. Special leave to appeal by the Supreme Court. 1. Notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence of order in any cause or matter passed or made by any court or tribunal in the territory of India. 2. Nothing in clause 1 shall apply to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. 2. Object the rapid growth of administrative law has brought into existence many administrative tribunals and adjudicating bodies. They are invested with wide judicial and quasi-judicial powers, thereby necessitating effective control. With this object in mind, the framers of the Constitution have conferred very wide and extensive powers on the Supreme Court. 3. The article commences with the words notwithstanding anything in this chapter. These words indicate that the intention of the founding fathers of the Constitution was to disregard in extraordinary cases the limitations contained in the previous articles on the power of the Supreme Court to entertain appeals. The Supreme Court can grant special leave and hear appeals even though no statute makes provision for such an appeal. However, Article 136 does not confer a right on any party but confers a discretionary power on the Supreme Court. In other words, a party cannot approach the Supreme Court under Article 136 as of right. The grant of special leave to appeal is, thus, entirely a matter of discretion of the Supreme Court. 4. The language of Article 136 is very wide and comprehensive. When Supreme Court may refuse leave. Though this power is comprehensive and undefined, the court has imposed certain limitations upon its own powers. This power is extraordinary and it should be exercised only in exceptional circumstances. Thus, the Supreme Court would not ordinarily grant a leave against the order of a tribunal where the alternative remedy is available, or finding of act is challenged, or the matter falls within the discretion of the authority, or where a new point is raised for the first time before the Supreme Court, or where the petitioner is unable to show the presence of special circumstances to grant special leave. When Supreme Court may grant leave, on the other hand, in the following circumstances the Supreme Court would entertain the appeal under Article 136, where the tribunal has acted in excess of jurisdiction or has failed to exercise jurisdiction vested in it, or where there is error apparent on the face of the record, or where the order is against the principles of natural justice, or where irrelevant considerations have been ignored, or where the findings of the tribunals are perverse, or where there is miscarriage of justice. Q. 46. Discuss about supervisory jurisdiction of High Court under the Constitution of India. Ans. Article 227 of the Constitution confers on every High Court the power of superintendence over all the subordinate courts and inferior tribunal in the state. Object: the underlying object of this provision to make the High Court the custodian of all justice within the territorial limits of its jurisdiction, and to arm it with a weapon that could be wielded for the purpose of seeing that justice is meted out fairly and properly by the authorities mentioned therein. This jurisdiction extends to keeping the subordinate courts and inferior tribunals within the limits of their authority and to seeing that they obey the law and they do what their duty requires and they do it in a legal manner. This jurisdiction cannot be limited or fettered by any act, except by a constitutional amendment. Nature and Scope in Variam Singh v. Amarnath, AR 1954 SC-15, it was observed that Article 227 of the Constitution confers on every High Court a special power and responsibility over all subordinate courts and tribunals within its territorial jurisdiction, with the object of securing that all such institutions exercise their powers and discharge their duties properly and in accordance with law. The power of superintendence over inferior courts and tribunals conferred on High Court is judicial as well as administrative. The power conferred by this provision on every High Court is unlimited and unfettered. In Sadhana Lord v. National Insurance Co. Limited, AIR 2003 SC 1561, it was observed that the supervisory jurisdiction conferred on the High Courts under Article 227 of the Constitution is confined only to see whether an inferior court or tribunal has proceeded within its parameters and not to correct an error apparent on the face of the record, much less an error of law. In exercising the supervisory power under Article 227 of the Constitution, the High Court does not act as an appellate court or the tribunal. It is also not permissible to a High Court on a petition filed under Article 227 of the Constitution to review or reweigh the evidence upon which the inferior court or tribunal purports to have passed the order or to correct errors of law in the decision. In State of Maharashtra v. Milind AIR 2001 SC 393, it was observed that the power of the High Court under Article 227 of the Constitution of India, while exercising the power of judicial review against an order of inferior tribunal being supervisory and not appellate, the High Court would be justified in interfering with the conclusion of the tribunal only when it records a finding that the inferior tribunal's conclusion is based upon exclusion of some admissible evidence or consideration of same inadmissible evidence, or the inferior tribunal has no jurisdiction at all, or that the finding is such which no reasonable man could arrive at on the materials on record. In Sadhana Lord v. National Insurance Co. Limited, AIR 2003 SC 1561, it was observed that where a statutory right to file an appeal has been provided for, it is not open to High Court to entertain a petition under Article 227 of the Constitution. Even if where a remedy by way of an appeal has not been provided for against the order and judgment of a district judge, the remedy available to the aggrieved person is to file a revision before the High Court under Section 115 of the CPC. Where remedy for filing a revision before the High Court under Section 115 of CPC. In Sadhana Lord v. National Insurance Co. Limited, AIR 2003 SC 1561, it was observed that where a statutory right to file an appeal has been provided for, it is not open to High Court to entertain a petition under Article 227 of the Constitution. Even if where a remedy by way of an appeal has not been provided for against the order and judgment of a district judge, the remedy available to the aggrieved person is to file a revision before the High Court under Section 115 of the CPC. Where remedy for filing a revision before the High Court under Section. In Sadhana Lord v. National Insurance Co. Limited, AIR 2003 SC 1561, it was observed that where a statutory right to file an appeal has been provided for, it is not open to High Court to entertain a petition under Article 227 of the Constitution. Even if where a remedy by way of an appeal has not been provided for against the order and judgment of a district judge, the remedy available to the aggrieved person is to file a revision before the High Court under Section 115 of the CPC. Where remedy for filing a revision before the High Court under Section 115 of CPC has been expressly barred by a state government, only in such case a petition under Article 227 of the Constitution would lie and not under Article 226 of the Constitution. Q. 47. What do you understand by Ombudsman? What are the function and power of Ombudsman? Ans. Ombudsman means a delegate, agent, officer or commissioner. A precise definition of Ombudsman is not possible, but Garner rightly describes him as an officer of Parliament, having as his primary function the duty of acting as an agent for Parliament, for the purpose of safeguarding citizens against abuse or misuse of administrative power by the executive. The literal meaning of Ombudsman is a delegate or agent. In the words of Professor S. K. Agarwala, the term Ombudsman refers to institutions which have three basic and unique characteristics. I. The Ombudsman is an independent and non-partisan officer of the legislature who supervises the administration. 2. He deals with specific complaints from the public against administrative injustice and maladministration, or may proceed on his own information in similar circumstances. 3. He has the power to investigate, criticize and report back to the legislative, but not to reverse administrative action. Usually, the Ombudsman is a lawyer, professor or judge with no political or financial axe to grind. He is paid very well and is elected for 4 years term. He makes a detailed annual report to the Parliament and he sets out the reactions of the people against the government, their complaints against it together with his recommendations for eliminating the causes for the complaints. Historical growth. This institution originated in Sweden in 1809 and thereafter it has been accepted in other countries including Denmark, Finland, New Zealand, England and India. Lokpal and Lokayukta. Powers and duties. The Ombudsman inquires and investigates into complaints made by citizens against abuse of discretionary power, maladministration or administrative inefficiency and takes appropriate actions. For that purpose, very wide powers are conferred on him. He has access to departmental files. The complainant is not required to lead any evidence before the Ombudsman to prove his case. It is the function and duty of the Ombudsman to satisfy himself whether or not the complaint was justified. He can even act suo motu. He can grant relief to the aggrieved person, as unlike the powers of a civil court, his powers are not limited. The authority of Ombudsman extends to the police, the armed forces, and the personal houses, the hospital and mental health authorities, and to the whole of the civil service. The only institutions exempted from his cognizance are 1. Parliament, 2. Law courts, and 3. Autonomous local councils. Anyone may complain to him. Letters from convicted persons are uncensored. Furthermore, he need not wait for complaints, he can take action suo motu. He can examine any activity, civil or military, look into even secret files, and summon anyone to appear before him and grant legal aid to sue any branch of the government. When he considers that a minister has to be made answerable at law for his conduct or official acts, he can recommend Parliament to call him to account. Q. 48. What is the position of Ombudsman in India? Ans. Ombudsman in India, inspired by the view that there is no adequate procedure or mechanism to redress individuals' grievances against administrative evils, the office of Lokpal, similar to that of the Ombudsman, has been recommended by the Administrative Reform Commission in its interim report. A draft bill has also been appended to the interim report of the Commission. Broadly on the basis of that bill, attempts have been made by the government to put new drafts of the Lokpal Bill 1969 and 1971, but it could not be enacted as it lapsed. Lokayukta in states. Several states in India enacted the Lokayukta statutes. These states are Orissa, 1970, Maharashtra, 1971, Rajasthan, 1973, Bihar, 1973, Uttar Pradesh, 1975, under UP Lokayukta and UP Lokayukta Act, 1975, the Lokayukta should be appointed by the Governor with the consultation of the Chief Justice of the High Court and Leader of the Opposition in the Legislative Assembly. Up Lokayukta shall be appointed with the consultation of Lokayukta. The Lokayukta shall be a person who is or has been a judge of the Supreme Court or a High Court. He should neither be a member of any legislature nor connected with any political party or any profession. He shall hold office for 5 years. The Lokayukta or Up Lokayukta may investigate any action taken by a minister or a secretary, or b. any public servant including a public servant notified for this purpose by the state government. He will investigate the matter on complaint, which must be accompanied by an affidavit, and complaint should not have any other remedy. The state government may exclude any complaint involving a grievance or an allegation against a public servant from the jurisdiction of the Lokayukta or Up Lokayukta. On complaint, if the Lokayukta or Up Lokayukta is satisfied on investigation that injustice or undue hardship has been done, he shall recommend to the public servant and the competent authority concerned that such injustice shall be remedied or redressed. If he is not satisfied with the action, he may make special report to the Governor. The Lokayukta and Up Lokayukta shall present annually a consolidated report on the performance of their functions under the Act to the Governor. The Lokpal Bill of 1977. This bill refers only to the Central Administration. It provides for the appointment of one Lokpal by the President of India after consultation with the Chief Justice of India and the Speaker of Lok Sabha and the Chairman of Rajya Sabha. His term of office will be 5 years and he cannot be given second term or any employment under the government. Before fixed tenure, he can be removed from his office in the same manner as there is provision for the removal of judge under Judges Inquiry Act 1968. The bill does not positively lay down any qualification for the appointment of the office of Lokpal. But it lays down negative qualifications, e.g. he shall not be a member of Parliament or of state legislature, should not hold any office of profit or trust, should not be related to any political party, etc. The salary, pensions and other perquisites of the Lokpal are equal to that of the Chief Justice of India. He may investigate into any administrative action taken by or with the approval of a minister or secretary of the union or a state government on receipt of a written complaint. In respect of grievance, the Indian Ombudsman, Lokpal will broadly cover administrative action which is unreasonable, unjust, oppressive or improperly discriminatory contrary to law, based on mistake of law or fact. Everybody who is not a public servant shall be entitled to file the complaint, which should be in prescribed form and supported by an affidavit. A fee of 1,000 rupees, 1,000, has to be deposited for meeting the expenses of the investigation. The Lokpal may exempt this fee, if satisfied on some adequate grounds. The investigation shall be conducted in camera, unless decided otherwise, for which reasons have to be recorded by the Lokpal. He has been given powers of a civil court for several matters. The proceedings before him shall be deemed to be judicial within the meaning of Section 193 of the Indian Penal Code. He will communicate his conclusions and recommendations in writing to the competent authority after the allegations made out in the complaint are partially or completely proved. The competent authority has to communicate the proposed action to Lokpal within 3 months. The Lokpal shall submit a consolidated report every year with respect to the administration of this Act. The institution of Lokpal is immune from judicial control of inferior courts, but not the jurisdiction on the High Court under Article 226 and Article 227 of the Supreme Court under Article 136. Unless the Constitution itself is amended to that extent. Q49. What do you understand by public corporation? Discuss their importance in modern times. Enumerate some of the important public corporations in India and discuss their working. Ans. As discussed earlier, policy of laissez-faire was given away. State is no longer confined to work of law and order only but has also become welfare state ensuring social security and welfare. Keeping in view this object, government entered into field of trade and commerce giving rise to public corporations. The public corporation, in the words of Professor Wade, is a hybrid organism, showing some of the features of government department and some of the features of a business company, and standing outside the ordinary framework of central and local government. The corporations are semi-governmental, autonomous bodies, primarily concerned with managerial, commercial and industrial enterprises, and run various public utilities, which the state does not choose to run departmentally as its normal government function. It is a ready instrument of the public enterprise and manages the nationalized undertaking. With a view to achieving the objectives of socialistic pattern of society, the framers of our Constitution in unequivocal terms mentioned a specific provision in the chapter of Directive Principles of State Policy which provides as follows. The state shall so direct its policy, that a. The ownership and control of material resources of the community are distributed to subserve the common good, and b. The operation of the economic system shall not result in the concentration of wealth and means of production to the common detriment. Article 39 of the Constitution. The above provision naturally gave impetus to public sector. It can be said that a corporation created by or under a statute possesses the following main characteristics. 1. A corporation is established by or under a statute. It possesses an independent corporate personality and it is an entity different from the union or the state government. 2. There may be several members or shareholders of a corporation. The law, however, knows only one body corporate. Juristic personality of corporation is distinct from its individual members. 3. A corporation exercises its rights, performs its functions, and discharges its duties and obligations entrusted to it by its constituent statute. Its powers do not extend beyond what the statute provides expressly or by necessary implication. 4. Every action of a corporation not expressly or impliedly authorized by the statute or charter is ultra vires and having no legal effect whatsoever. 5. A corporation can possess, hold and dispose of property. 6. Subject to the provisions of the statute by or under which a corporation is created, such corporation is by and large an autonomous body. Even though the ownership, control and management of a corporation might be vested in the union or the state. 7. The constituent statute or charter may delegate the rule-making power to a corporation. 8. A corporation created by or under a statute can be said to be an agency or instrumentality of the government and its state within the meaning of Article 12 of the Constitution, and therefore is subject to the jurisdiction of the Supreme Court under Article 32 and the High Courts under Article 226 of the Constitution. 9. Employees of a corporation do not hold civil post under the Union or the state within the meaning of Part 14 of the Constitution of India. A corporation cannot be said to be a citizen within the meaning of Part 2 of the Constitution and, therefore, it cannot claim benefits of those fundamental rights which have been conferred only on the citizens. The public corporation in India can be classified under three heads. I. Financial corporations, like the LIC, Reserve Bank of India, Export Credit and Guarantee Corporation Limited, Film Finance Corporation Limited, etc. 2. Promotional and development corporations, like Food Corporation of India, Rehabilitation Housing Corporation Limited, National Research Development Corporation Limited, etc. 3. Commercial and industrial corporations such as State Trading Corporation, Hindustan Machine Tools Limited, Indian Airlines Corporation, etc. Working of public corporations. The constitution of the corporations and their functions, powers and duties may be understood by a study of the actual working of a few public corporations. I. Reserve Bank of India, RBI. The Reserve Bank of India was constituted under the Reserve Bank of India Act, 1934. It was nationalized in 1948 by the Reserve Bank, transferred to Public Ownership Act, 1948. It was primarily established to regulate the credit structure, to carry on banking business and to secure monetary stability in the country. A board of directors, consisting of a governor, two deputy governors and a number of directors manages it. They are appointed by the central government for a term of 5 years and are eligible for re-employment. Under the Banking Companies Act, 1949, the Reserve Bank has extensive powers over the banking business in India. It grants licenses without which no company can carry on banking business. Before granting such license, it can inquire into the affairs of the company to satisfy itself as regards the company's capacity to pay back to its depositors. It can cancel a license on the ground that the conditions specified therein have not been complied with. Even after granting such a license, it may inquire into the affairs of any bank, inspect its books of accounts, and hold an investigation either under the direction of the central government or suo motu. The report of the inquiry will have to be sent to the central government. Very wide discretionary powers have been conferred on the Reserve Bank. It determines the policy relating to bank advances, frames proposals for amalgamation of 2 or more banks. It may make a representation for the operation of the Banking Companies Act to be suspended. The governor of the bank is empowered to suspend the operation of the Act for 30 days in an emergency. 2. Oil and Natural Gas Commission, ONGC. The commission was first established in the year 1956 as a government department. By the Oil and Natural Gas Commission Act, 1959, the commission was given a status of a public corporation. The commission consists of a chairman and 2 or more, not exceeding 8, members, to be duly appointed by the central government. Except a finance member, others may be part-time or full-time members. The central government prescribes the rules fixing their terms of office and conditions of service. It can remove any member even before the expiry of the period, after issuing a show-cause notice. Its functions range from planning, promotion, organization or implementation of programs for the development of petroleum resources to production and sale of petroleum products it produces. It conducts geological surveys for the exploration of petroleum and undertakes drilling and prospecting operations. The Commission determines its own procedure by framing rules and its decisions are by majority vote. The government can acquire lands for the purposes of the Commission under the provisions of the Land Acquisition Act, 1894. 3. Damodar Valley Corporation, DVC. The Damodar Valley Corporation was established under the Damodar Valley Corporation Act, 1948. Like other corporations, it is a body corporate having perpetual succession and a common seal. The Board of Management consists of a chairman and 2 members appointed by the Government of India in consultation with the governments of the states of Bihar and West Bengal. The members are whole-time, salaried employees of the corporation. The Government of India is empowered to remove and member any member for incapacity or abuse of position. The objects of this corporation are to promote and operate irrigation schemes, water supply, drainage, generation of electricity and electrical energy, navigation, etc. in the river Damodar. The river is well known for its notorious propensities. Due to heavy flooding which causes widespread damage and destruction in the states of Bihar and West Bengal, one of the important objects of the corporation is flood control. It is empowered to establish, maintain and operate laboratories, experimental institutions, and research stations to achieve the above-mentioned objects. It helps in construction of dams, barrages, reservoirs, powerhouses, etc. It supplies water and electricity and can levy rates for it. The corporation is empowered to acquire, hold and dispose of property. It has its own funds deposited in the Reserve Bank of India. It can borrow money with the previous approval of the Government of India. It has a separate and independent existence, and it is an autonomous body independent of the central or the state governments. There is no interference by the government in the matter of execution of its programs and day-to-day administration. Nevertheless, the corporation is subject to overall control of the central government, Parliament, and the state legislatures of Bihar and West Bengal. It has to send its annual reports to the governments. They are placed on the tables of Parliament and the two state legislatures. The accounts of the corporation are to be audited in the manner prescribed by the Auditor General of India. 4. Life Insurance Corporation of India. LIC. The Life Insurance Corporation of India was established under the Life Insurance Corporation Act, 1956. It shares certain common characteristics with the other corporations. It is a body corporate with perpetual succession and a common seal. It has power to acquire, hold and dispose of property. It can sue and be sued. The corporation was established to carry on life insurance business and given the privilege of carrying on this business to the exclusion of all other persons and institutions. The Act requires the corporation to develop the business to the best advantage of the community. The central government may give directions in writing in the matters of policy involving public interest. Such directions shall guide the corporation. 95% of the profits are to be reserved for policy holders and the balance is to be utilized as the central government may decide. The corporation is an autonomous body. It is free from ministerial control except as to the broad guidelines of policy. Road Transport Corporations, RTCs. Various state governments have established road transport corporations for their respective state under the Road Transport Corporation Act, 1950, e.g. Gujarat State Road Transport Corporation. A road transport corporation is managed by a chief executive officer, a general manager, and a chief accountant appointed by the state government concerned. The central government contributes the capital in part, while the remaining capital is to be borne by the state government concerned in agreed proportions. The corporations can raise capital by issuing non-transferable shares. The government guarantees the capital, the shares, and the dividends. The primary function of the corporation is to provide efficient, adequate, economical, and a properly coordinated system of road transport service in the country. The state government is empowered to issue general instructions for the efficient performance of the functions of the corporation. It manufactures, purchases, maintains and repairs rolling stock, appliance, plant and equipment. It can acquire, hold and dispose of property. 6. State Trading Corporation, STC. State Trading Corporation of India is a government company. The government wholly owns the central government and two secretaries of the Government of India hold it and all the shares. The object of the corporation as laid down in the Memorandum of Association is to organize and undertake generally with the state trading countries as also other countries in commodities entrusted to it for such purpose by the central government from time to time the purchase, sale and transport of such commodities in India or anywhere else in the world. Since it is constituted under the Companies Act, 1956, all the provisions of the Act apply to it. A competent court can wind it up. Its functions are commercial in nature. It is neither a department nor an organ of the Government of India. Q. 50. Discuss about Parliamentary and Government Control over Public Corporation. Ans. Parliamentary control. One of the principal reasons that had led to the establishment of public corporation instead of departmental undertaking is the desire to avoid detailed parliamentary scrutiny. This does not mean that public corporations enjoy complete freedom from such control. Parliament's right to keep an eye over the working of public corporations is undisputed in any diplomatic country. The following process has been adopted for controlling the corporations. 1. Legislation. The parliamentary control begins with the very act of legislation which brings the corporations into existence. Parliament in India does take great pains to fulfill this responsibility. 2. Laying of rules and regulations. By this process, some of the acts setting up public corporations provide that rules made under these acts are to be laid before Parliament. 3. Questions. Under Rule 32 of the Rules of Procedure of the Lok Sabha, unless Speaker otherwise directs, the first hour of every sitting shall be available for the asking and answering questions. 4. Half-an-hour discussion. Under Rule 55 of the Rules of Procedure of the Lok Sabha, the Speaker can provide half an hour for raising discussion on a matter of a recent question and answer which needs elucidation on matter of fact. 5. Statement by Ministers. Under Rule 372 of the Lok Sabha Rules, Minister may make a statement on a matter of public importance with the consent of the Speaker. So far, however, the method has not been used extensively in the matter of public corporations. 6. Resolution. Discussion on matters relating to public corporation may occur through the medium of resolution, Rules 136 and 137 of the Rajya Sabha Rules. 7. Motions. Actually, motions provide the general form of discussion of matters related to a public corporation, while the other procedures afford special opportunities. 8. Parliamentary Committee. In 1957, Estimates Committee recommended that public undertakings should prepare a performance and program statement for the budget year together with the previous year statement, and it should be made available to Parliament at the time of the annual budget. Government control. The government exercises control over public undertaking through various ways. It exercises the power to appoint and remove the chairman, directors or members of the board and the managing director. The government also controls the appointment of senior executive officers. The rule regarding the regulation of constitution of services of employees of these public corporations require the approval of the government. The Controller and Auditor General exercises varying degree of control in the matter of audit of accounts of the corporations. A. Appointment and removal of members. Generally, the power of appointment and removal of the chairman and the members of a public corporation is vested in the government. This is the key provision and the most effective means of control over a public corporation. In some statutes, a provision is made for removal of a member on the ground that the member is absent from meetings for a specified period, he is adjudged a bankrupt or is otherwise unsuitable to continue as a member. B. Finance. The government exercise effective control over a public corporation when such corporation is dependent on the government for finance. A statute may require previous approval of the government for undertaking any capital expenditure exceeding a particular amount. It may also provide to submit to the government its program and budget for the next year and to submit the same in advance. It may also impose a condition on the corporation to take consent of the government before borrowing money or may insist for issuance of bonds and debentures to secure payment made by the government to the corporation. The Controller and Auditor General exercises control in the matter of audit of accounts submitted by public corporations. C. Directives. An important technique involved to reconcile governmental control with the autonomy of the undertaking is to authorize the government to issue directives to public undertakings on matters of policy without interfering with the matters of day-to-day administration. A statute may empower the government to issue such directives, as it may think necessary on questions of policy affecting the manner in which a corporation may perform its function. D. Rules and regulations. Usually a constituent statute creating a corporation contains provisions to make rules and regulations. The provision empowers the central government to make rules to give effect to the provisions of the Act. The other provisions authorize the corporation, with the prior approval of the central government, to make regulations not inconsistent with the Act and the rules made thereunder for enabling it to discharge its functions under the Act. Thus, even in case of framing rules and regulations, the government is having the upper hand. Regulations promulgated without previous approval of the government cannot be said to be valid.